break, we're going into that California courtroom. We're going to play out this whole hearing from yesterday, from start to finish, and here is the start.
On behalf of Mr. Bohm, who is present in court out of custody. Thank you.
Nathan Martos, along with Pauline Gazarian, for the people.
Thank you. Is there help in here, too? There it is.
Hello, Your Honor.
Hello.
Mr. Commander, he's here. We'd ask the court to recall the bench warrant that was, or the body attachment that was held till today's date.
So, thank you.
Thank you.
The matter's here for hearing on the 995 motion that Mr. Jackson is sprung to file, which I have read and considered, as well as the people's opposition and the defense reply. I've read all of those several times, as well as the preliminary hearing transcript, and I have reviewed the exhibits for the preliminary hearing that were committed into evidence as well. Who's going to handle the, Mr. Jackson going to handle it? Okay.
The 995, yes.
Yes, obviously I've read your written submission, but if you would like to add to it, this is the opportunity. Thank you.
Your Honor, thank you, first of all, for allowing us to be heard on this. I will try not to repeat myself. Obviously, the court has read our submission, we've read all the exhibits, the preliminary hearing transcript, but I think that there are certain issues that do bear on the court's ultimate determination, and I'm going to highlight those issues as best I can and as succinctly as I can. It starts with one truth, a legal truth here in California. Speed cannot be treated as malice. Speed cannot be treated as malice. That is the rule in the state of California. It's not made up by the defense, it's not made up by me. It's not a tagline. It's the rule of law in California recited in a statement handed down to the lower courts by the Supreme Court Justice Kelly Evans. Your Honor, this case has always required one thing and one thing only from the prosecution, and that is proof of implied malice. Not proof of negligence, not proof of recklessness, not proof that this was a tragedy, which it clearly was. They must prove implied malice, and the law is crystal clear that implied malice has two separate and independent requirements: an objective requirement and a subjective requirement. The prosecution has never satisfied either of those, certainly not the preliminary hearing. And I want to be very clear, right now, at least for the first part of my comments, I want to separate those two into different legal pillars. The first thing I want to address is the objective requirement. What act did Fraser Bohm commit that objectively involved a probability of result in death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway, I could not be clearer about this. It was a tragic collision. But tragedy does not equal murder. And the law does not permit the district attorney to convert a fatal accident into second-degree murder simply by calling speed malice. Because we go back to that first postulate, speed cannot be malice in California. Your Honor, there was no alcohol, no drugs, no testing.
Alan Jackson making his plea. We'll get a break. When we come back, we'll roll out the rest of this hearing. Stay with us.
TV.
This is Court TV Live. I'm Kelly Craft alongside Matt Johnson. Thank you for being with us today. And we begin this hour in California, where defendant Fraser Michael Bohm was back in court yesterday to try and have his murder charges dropped.
Yeah, defense attorney Alan Jackson is arguing that the 4 murder charges against Bohm should be dropped
calling the deadly October crash an accident and not murder.
But prosecutors say Bohm was traveling more than 100 miles per hour when he crashed his BMW into some parked cars, which fatally struck 4 Pepperdine University students.
But the defense says that Bohm was trying to flee a road rage incident, and this all happening back in 2023.
Let's get you back into the courtroom now. This is more of Alan Jackson's arguments for the defense.
Before we go any further to the facts, the record, the evidentiary defects that were at the preliminary hearing, we need to start with what the Supreme Court has already started for us, and that is the Reyes case. Because if this court applies the law as it exists today, which this court must do, not as it existed before 2023, then the murder counts cannot stand. They are legally infirm. Period. Full stop. The Supreme Court in Reyes made it unmistakably clear that to prove implied malice, the act itself must involve a high degree of probability, not possibility, probability, that it will result in death. That's not a risk, Your Honor. That's not dangerous in a generalized way. We can have possibility and danger that still do not reach the level of implied malice. It must be a high probability of death, not just a probability. And that means significantly more likely than not. I tried, as I was preparing my arguments today, to put this in terms that ring true to we lawyers and the community members at large as well. A high probability of death means it is significantly more likely than not just 51%. The famous scales with that, more likely than not. That you're going to kill someone when you commit that act. That you're going to kill someone when you commit the act. They rely on speeding. That's it. That's their entire theory. I've provided the court with 2 copies of the Courtroom. I just wanted to make sure that we're absolutely clear about the language difference between those, the old and the new. They're marked. One copy is the Courtroom the people actually relied on. It was superseded and is no longer law. And one copy is the instruction post-Reyes, and that is the current law. In the old version, the objective standard, what I might have been arguing 10 years ago, before Reyes, highlights that, quote, implied malice requires an intentional act. The natural and probable consequences of the act were dangerous to human life. So be it. That's what the law used to be. But the correct law regarding the objective standard now reads as follows. The defendant has implied malice if he intentionally committed an act. The natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that it would, not may, it would result in death. The clearest language used by any court since Watson, defining a high degree of probability of death relating to traffic homicides, is the Moore case. The court explained in that case that Mr. Moore, the defendant in that case, drove 70 miles per hour on a neighborhood surface street, intentionally crossed into oncoming opposing traffic, causing other drivers to avoid him, intentionally ran through a red light at speed, struck a car in the intersection at speed without even attempting to apply his brakes, killed a passenger, and then evaded the police following that. And he did all of this, as he admitted, because of what he called, quote, wacky tobacco, end quote. That's a quote right out of the case, reasonably implying that he was high on marijuana at the time. The court in that case defined a high probability of death, and this is important, as a near certainty. A near certainty that the act would result in death. That's what a high probability of death means in California. Not that the act possibly could cause death, not that the act probably would cause death, not that the act was dangerous or even highly dangerous, but rather that it's a near certainty that the act alone would cause death. Did the people say or establish in any way at the preliminary hearing that the mere act of speeding on PCH, that's what their postulate is. The mere act of speeding on PCH is nearly certain to cause death. That is absurd. They did not, because they cannot. It is objectively not true that speeding on PCH nearly always causes death. In fact, it does not, and the people well know it. So that objective factor, and the act claimed by the people as a high probability of causing death, has simply not been met. It wasn't met at the preliminary hearing. Therefore, there is no implied malice to prove this case, or to prove those charges. That is the controlling law in California, and it's simply not the standard that the prosecution applied, and it's not the standard that the magistrate applied, respectively. The prosecution argued at the preliminary hearing, and what the magistrate ultimately accepted is the old formulation, that an act is sufficient to satisfy the objective requirement if it's dangerous to human life. And again, if we were standing here arguing this in 2015 or in 2022 for Reyes, I might not even be making this argument. But here we are in 2025, post-Reyes, and that's no longer the law. Danger is no longer enough. The Supreme Court expressly rejected that diluted standard and replaced it with a far, far more narrow standard. And that matters in this case. This is that type of case where the law actually makes a difference. The law actually defines what this court can and should do. Because failing the objective prong just ends the inquiry. We're just done. If the act does not objectively involve a high probability of death, there is no implied malice, even if the defendant was fully aware of the risk. And in this case, he wasn't, which I'll get to in just a second. The Supreme Court Justice that I referred to earlier, Justice Evans, has already anticipated and warned against the exact mistake that the people are making in this case. She literally saw it coming, the exact arguments that they're making, and warned the lower courts against that argument. In a published statement following Reyes, Supreme Court Justice Evans explained that lower courts in vehicular cases have been ignoring the objective standard, applying outdated Courtroom language, and treating speed as if it were inherently sufficient to show implied malice. It doesn't get much clearer than that. She stated plainly, quote, and this is her quote, not mine, quote, speeding, even at a high rate, does not automatically equate to a high probability of death, end quote. That is not my characterization. That is a sitting California Supreme Court Justice explaining that in vehicular cases, you must apply the Reyes standard, and failing to do so is reversible error.
Coming up, how fast Fraser Michael Bohm was traveling takes center stage as Alan Jackson continues to argue to have the 4 murder charges dropped.
There's no evidence, none, that Fraser Bohm believed he was actually traveling at 100 miles an hour, 90 miles an hour, or 80 miles an hour. There's no evidence of that in the record whatsoever. The unrefuted evidence of what was subjectively in Fraser's mind is, the court read the transcript, I don't know, when asked over and over and over, how fast were you going? He said, I don't know.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge-watching Bull. Sundays on Court TV.
They were the most amazing people I have ever met. And I don't just say that. I genuinely, I can't even put into words how perfect they were. They were the most amazing friends, the most amazing students, classmates. To know them was to really love them, and to know them was to be loved by them. they made everyone feel seen, feel heard, feel loved.
Speaking with our Julia Janae there, a friend remembering the victims, the 4 University of Pepperdine college students who were tragically killed along PCH, otherwise known as Pacific Coast Highway, back in October of 2023.
Then 22-year-old Fraser Michael Bohm is accused of crashing his BMW into some parked cars, which crashed into the seniors who were set to graduate in just a few months.
And all sorority sisters, they were out celebrating that night, but the defense argues that Bohm was actually fleeing a road rage incident and a driver at the time, which caused him to lose control on PCH and crash.
Let's get you back into court now. More of defense counsel's Alan Jackson's arguments.
At the preliminary hearing, the prosecution's argument was there has to be a number where speed becomes murder. There has to be a number where speed becomes murder. It's undefined. There just has to be one, Your Honor, where speed becomes murder. That was their theory then. They told the magistrate that speed itself was both the objective and the subjective proof of implied malice, and even in their reply papers, they do the same thing today. Objective and subjective determination of the lethality of speed. They're still continuing to make the same legal error. That's not the law. There is no magic number at which speed automatically becomes murder. The law doesn't permit implied malice to be inferred from some undefined mileage per hour or even a defined mileage per hour. And the Supreme Court in Reyes and after Reyes has explicitly warned courts not to collapse those two objective and subjective standards or prongs into one single fact, like, for instance, speed. In the opposition, the people have abandoned their original argument. They've tried to replace it with something even more legally deficient. The idea that Fraser's general familiarity with the phrase, quote, speed kills, that slogan, proves both knowledge and conscious disregard, because once he heard the slogan, or because one time he may have heard the slogan or saw it somewhere on the side of a bus or a bus bench. That is not proof of subjective malice. That is proof that the defendant is a human being who's seen the same public safety billboards that you and I have seen and the rest of us, everybody in the audience has seen and are familiar with. Think about it. If this court, Your Honor, were to uphold the people's improper theory, every time there's a vehicular fatality, pretty much every time, all the officer would need to do is say, have you heard that speed kills? And if the unsuspecting driver says yes, now they're facing murder charges? Implied malice requires the defendant to have actually appreciated the specific danger of his or her act at that time. Not a general awareness that speeding somewhere, sometime, somehow may be dangerous. The requirement is this. I know the act is nearly certain to kill someone, and I'm going to do it anyway. That's the standard that's set out by the Supreme Court. I know the act I'm about to engage in is nearly certain to kill someone. I'm going to do it anyway. That's implied malice. That's the subjective factor. Nothing in the record comes close to that standard, Your Honor, and the people know that, which is why they're trying to replace evidence with inference and slogans like speed kills. The people also want to rest on the fact that Fraser knew friends who died in an automobile accident at some point in his past. They want to suggest that that's enough for his subjective intent to consciously disregard the near certainty that speeding can kill someone. We all likely know someone tragically who has passed in some sort of traffic accident. I'll bet if I asked for a showing of hands in this courtroom, very few wouldn't go up if I said, do you know someone or know someone who knew someone who tragically passed in a traffic accident? But under the law, that's not the same as being sensitized to the consequences of certain acts. That's what the law requires. We have yet to find any case in all our research in which that was the predicate for the subjective requirement. And yet every case that we have found, including Ortiz, which we cited, states the opposite. The subjective requirement can be established only from suffering serious consequences from the government because of your own conduct. That's Watson. This court knows that case inside and out. That's Watson. The defendant has suffered sanctions by the government, warnings by the government in judicial proceedings, in a judicial governmental environment, that warned him against the very act he then went out and did again. That is missing here. The people cannot replace Fraser's subjective knowledge with a traffic slogan and somebody else's traffic collision. That's not the law. The court has never done it, and I seriously doubt that this court wants to be the first. Thus, the prosecution cannot satisfy the subjective component either of murder or implied malice. There's no evidence, none, that Fraser Bohm believed he was actually traveling at 100 miles an hour, 90 miles an hour, or 80 miles an hour. There's no evidence of that in the record whatsoever. The unrefuted evidence of what was subjectively in Fraser's mind is, when the court read the transcript, I don't know, I don't know, I don't know, when asked over.
Let's go ahead and bring in our guest for this hour to discuss. Joining us now from Baltimore, Maryland, trial attorney and former prosecutor Randolph Rice, and from Salem, Massachusetts, former chief trial counsel Richard Grundy. Gentlemen, thank you so much for being with us today. Randolph, I want to start with you. We're listening to Alan Jackson's arguments. What do you make of them?
Well, he's doing a good job. He's doing what he's supposed to be doing. He's fighting at every stage of this case, and he's making every possible argument he can make to try to get these charges knocked down so that when they go to trial, his client is in the best possible position in front of that jury to have the lowest possible consequence.
Yeah, and you know what's at stake here for the California legislature and for the possible penalty, we've both worked in Los Angeles and California, is really, according to the legislature, the malice murder. And that could be life in prison for each of these 4 counts versus, you know, gross vehicular homicide, which is, you know, a penalty of 2, 4, 6 years. He wasn't intoxicated, so that doesn't go up to 10. But when you're hearing these arguments, the DA's office did release a statement as to why they're sticking to their guns on this and keeping those charges of murder. They released a statement to KNBC station, and it says this in part: the evidence will show the consciousness disregard for human life. That's why murder charges are absolutely warranted. Our office stands resolutely by the victims when their innocent lives were stolen through such reckless and preventable conduct. This was not a tragic mistake. It was a deadly act of extreme recklessness, as we will prove in court. When somebody knowingly drives at an outrageous speed on a public road, they turn their vehicle into a lethal weapon. So, Rick, what do you make of that? As a former prosecutor, what are your thoughts on this?
Well, there's a couple things. First off, you know, I'm up here in Boston, so I'm having a little bit deja vu while watching Mr. Jackson, who looks like he got his one hand caught in the cookie jar there. But he's arguing a specific isolated point, which when you open that up to the other factors is mooted. And that is that it's not just speed, it's outrageous, excessive speed, which in Massachusetts and many other jurisdictions would statutorily accommodate another crime of driving recklessly, driving to endanger, etc. On a known dangerous highway, and clearly in a situation going into a part of the roadway which could not be negotiated safely. So those are the other factors that go into the speed that's being isolated by Alan Jackson in creating this to a murder case. The other aspect that's going on here is these cases are very difficult from all sides because very often they are exactly what you have here. You have the highest possible injuries occurring, 4 deaths, and you have an individual, no prior record, young, a minute or so of their life they've acted out. People on one side want as much max prison time as they can get. The other side have a relatively clean slate of a defendant.
Yeah, and you know what's at stake here for this particular hearing is how the trial moves forward and what that looks like, right?
Yes.
And what the jury will be considering, because the jury, as we were talking off camera, is going to know about this case, but also how deadly that road is.
Yeah, that road is inherently dangerous. The judge talks about that. Everyone knows it is, especially that particular curve. The speed limit was 45 miles per hour. So we'll just have to continue to follow this and see what happens. Gentlemen, thank you.
Yeah, you're going to be sticking with us all hour long. Coming up, we'll continue to watch that motions hearing for Fraser Bohm. And stay tuned, because later on, Bohm's defense attorney, Alan Jackson, invokes the name of a cold-blooded mass killer when he argues for his client.
These are the same charges that Bryan Kohberger is facing. That's the point. Bryan Kohberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder.
And welcome back to Court TV Live. I'm Kelly Craft, along with Matt Johnson. Thank you for being with us. Let's head back now to Los Angeles, California. More of the motions hearing for Fraser Michael Bohm.
He's the young man charged with 4 counts of murder after a high-speed crash on PCH that killed 4 Pepperdine University seniors in Southern California.
Let's go back now into the courtroom. We are listening to some arguments from defense counsel Alan Jackson.
If Fraser did not know his speed, then clearly he could not have consciously disregarded a danger he didn't perceive. The Supreme Court has repeatedly said you can't disregard a fact you don't know. Further, unlike in the Moore case, which I cited to the court a little bit earlier, in Gonzalez, which is in our papers, where the defendants admitted that they knew that what they were doing had a high probability of death, and they didn't care. They knew exactly what they were doing in both of those cases. The defendants in both of those cases said, I don't care. There's no evidence that Fraser knew what he was doing was, quote, nearly certain, end quote, to kill anyone, a high probability of death.
Nobody wears a sign around their neck saying, my intent is to do this. My knowledge is so-and-so. It has to be judged by their actions and by the totality of the circumstances, doesn't it? Nobody comes out and says, my intention is to kill somebody when they point a gun at someone. My intention is to kill you. Nobody says that. You have to base your judgment as to what their intent was and their knowledge on their actions and on the circumstances surrounding it.
Circumstantial evidence has to be used to a certain degree. Absolutely, I agree with that. Nobody wears the sign around their neck saying, I intend to do this. But in every case in which that subjective knowledge has been imputed to a defendant, in every case, Ortiz, Gonzalez, Moore, all those cases have evidence in the record that the defendant knew what he was doing had a high probability of death and then ignored it, intentionally ignored it, through his statements, through his conduct after the fact, through fleeing after the fact, trying to avoid prosecution after the fact, saying, I knew I was going to go through the intersection. In Moore, for God's sake, the man drove through an intersection, killed a pedestrian, drove home, then said, when the officer said, well, you know what you did, didn't you? And he said, yeah, I think I cut the guy in half. It was disgusting. And there was subsequent post-conduct comments by all of those defendants to suggest they knew what they were doing and didn't care about it. That's the inferential evidence that was used in those cases, and that's what I'm highlighting to the court that we don't have with Fraser. He didn't know how fast he was going. He did not have that information.
That post-accident conduct, as disgusting as it was a factor, but it wasn't in and of itself determinative.
It was a factor that they used in addition to the other factors to indicate inferentially that they knew that their conduct at speeding on surface streets, high rate of speed, going through an intersection, etc., was inherently dangerous to a point that it was in that, as the jury instruction says, in that there was a high probability of causing death. That's what's missing, Your Honor. The court is exactly right in highlighting this. Of course, nobody's going to wear a sign or send a voicemail saying, I know what I'm about to do is nearly certain to cause death. The problem with the prosecution's case and the magistrate's holding order is that there's no evidence The record is completely deplete of evidence that Fraser knew how fast he was going. That's why I brought up his statements.
How would somebody driving 100 miles an hour or 90 or whatever the speed actually was up in that range not know that you're going super fast? How would you not know that? Realistically.
Super fast is not the standard.
No. But answer my question. If you're driving a car 95 miles an hour, you know you're not driving 40. Am I wrong about that?
You're not wrong about that. But speed alone is not.
I understand that.
Speed alone is not. It's not enough.
But to gauge a person's knowledge of what it is that they're doing, the consciousness of it, you have to use common sense as well. And I'm sorry, when you're driving 95 miles an hour, 100 miles an hour, you know you're driving extremely fast. You know that.
If other cars are driving 70, 75, 80 on Pacific Coast Highway, which, Your Honor, they do all the time. I mean, now we're just talking about perception, right? Now we're talking about the court's perception. You must perceive that you're going fast. I was on that road 2 weeks ago. There were sports cars passing me. I was going 70. By the way, that was above the speed limit. Didn't realize it because every car next to me was either going the same speed or going faster than me. It's a perception issue. It's not like he was going 70 or 80 or 90 miles an hour, whatever the speed is, which the prosecution cannot find in a 25 mile an hour zone right next to a school. He's on PCH. And other cars are going similar speeds. Yes, he may have been going faster than the cars next to him, but not to a degree that it's a near certainty to cause death.
Well,
and that's the point at which it would have to be.
I'm going to discuss the testimony of Freeland and what the underlying facts of the case are, but just as a preview, all of the evidence from the civilian witnesses in the case is that the defendant zoomed away far faster. They couldn't even come close to saying with him he was driving so fast. He was hundreds of yards ahead at the time of the crash.
The witnesses, not a single witness at the preliminary hearing put him going 100 miles an hour. Not a single one. As a matter of fact, the witnesses that were asked how fast do you think he was going, they estimated him going around 70. That was in the preliminary hearing transcript. I wasn't there. That's what they said. That is not extraordinary, and certainly that's not enough to suggest a near certainty that someone is going to die. It's just not enough. I'm not saying, and I don't want to get spun into a discussion or even an argument certainly with the court about was it dangerous. We can all agree speeding is dangerous. We can all agree that it has a possibility of causing death or great bodily injury. We can all agree with that. That's not the law.
Can we agree that the faster you're going, the more likely it is to cause death?
Depends on how fast you're going. Absolutely depends on how fast you're going. We can all agree on this. According to Justice Evans, that's not enough.
Right.
That is not enough by itself. And that's the only thing the prosecution has. Speeding. That's it. And that's noted. The people routinely charge vehicular manslaughter, not murder, just as the court is discussing in fatal speeding cases, unless there's clear evidence of the subjective knowledge.
Impassioned arguments there from
For sure.
18 years of serving as a prosecutor in Los Angeles. Alan Jackson there turned famous defense attorney. Let's bring in our guest to discuss this and those arguments, Randolph Rice and Rick Grundy standing by. Rick, I want to talk to you about this because you were there in Massachusetts with me when we were covering the Karen Reed case. And, you know, this is the defense attorney in both of those trials. He's also doing her civil case. But, you know, in that case as well, he presented an alternate theory. And in this case, it sounds like what that theory is you can't prove the speed. You can't prove intent of any wrongdoing that he wanted to kill himself or anybody else. But what does the defense look like in a case like this?
Well, I think we touched on it a little bit earlier. The best case scenario in this case from a defense attorney would be to get to a plea agreement wherein these higher charged murder counts are gotten rid of. But hearkening back to what I said, when you have 4 families on the other side who see this as nothing less than a first-degree murder. Getting to that is difficult, if not impossible. So he's trying to chip away at it at this point. I'm a little perplexed because just the pictures from what I've seen, you're going to have yaw marks, which are tire marks, gouge marks, which are the cars digging into the pavement. And there was one light-colored car that clearly showed the impact of his car. And all of that is going to be measured, and an expert's going to be able to say the car that left these tire marks, the car that caused this gouge, and the cars that went in causing this depth of damage to the car being driven and the car hit, the minimum speed had to be X, Y, or Z.
Yeah, I mean, that's going to be really important, Randolph, when we hear the differing arguments from Alan Jackson saying he was going one speed, the prosecutors claiming another speed. And one of the things that Alan Jackson just talked about with the judge, how does that resonate? You know, talking about PCH, in California, everyone drives so fast. I lived there, Matt lived there. You are flying, and if you're not going a certain speed, everyone is zooming past you, and sometimes you find yourself going faster than what you would think you are going just to keep up with everybody else.
Yeah, Kelly, that's a great point. You know, can they show that he was driving at a rate of speed that was consistent with what normally people drive on that highway? Another important factor that they may have, and I'm not sure the age of this car, I believe it was 2018, maybe 2017 BMW, was that typically these vehicles do have black boxes. They may be able to pull those boxes from that vehicle to determine this speed. But if it's the consistent speed, if it's what everybody else is driving, that's a great argument for the defense. If it's above that, it's going to be an issue.
Yeah. All right. Thank you, gentlemen. We're going to get a quick break. We're going to pick it up with more from that motions hearing in the Sorority Sisters murder case for Fraser Michael Bohm. More of those fiery arguments when we come back. Stay with us.
We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. But it wasn't a murder.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help, Barty, I'm dying.
Don't you have the blood of both these men on your hands?
I feel guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Welcome back to Court TV Live. Matt Johnson alongside Kelly Craft on this Veterans Day. We're going to head back to Southern California for more of that important motions hearing for Fraser Bohm, the man accused of killing 4 Pepperdine University college sorority sisters in a high-speed crash back in 2023.
Bohm is represented by Alan Jackson, who was Karen Reed's defense attorney in the killer or cover-up murder trial. Let's get you back into the courtroom now, right where we left off.
Fraser, by contrast, as established in the facts of the preliminary hearing, stayed at the scene, cooperated with investigators, no drugs, no alcohol on board, no driving history, no fleeing, no secondary criminal act, all of which this other case had. Like I said, the law is anything, it has to be deliberated, it has to be consistent. And that means that similar facts should produce similar charges. And less aggravated facts should never be charged more severely. Selective charging is not just unfair, Judge, as this court knows, it's unconstitutional. Here, there's not even evidence that Fraser intended to drive fast for its own sake. Every available piece of evidence supports the opposite, that he was reacting to events unfolding in the moment, including being chased, being clipped by another vehicle seconds before impact. That is not malice. I'm not arguing that it wasn't dangerous. That's not the law. The law is for malice. It has to be a near certainty to cause death, and he has to subjectively say, I know it, and I don't care. That's their burden. What we have before us is instinct, not intent, not subjective intent. This was not malice. This was an accident. Perhaps negligence, not murder. The people now argue in their papers that the cause of the crash, astonishingly, is irrelevant. That doesn't change his culpability. Let me say that again. The cause of the crash is irrelevant? Your Honor, this is a murder case. Causation is everything. If Fraser was clipped or swerved or reacted to external events, then his act was not the probable cause of death. That alone defeats the murder charge, and the people's own exhibits show driver's side contact with his car, white paint transfer, matching the damage to Ms. Ortiz's vehicle. The very facts that the prosecution sort of wants to pretend doesn't exist. And you cannot argue implied malice when the defendant's conduct was reactive rather than intentional. Your Honor, Section 995 exists for exactly this reason, to purge charges that sound grave or rest on legally unsupported theories. The Supreme Court has repeatedly instructed that 995 motions must be granted when the magistrate applied the wrong legal standard, not just where the evidence is weak, but where the governing law and the governing elements were misapplied. And that's what happened in this case. It's precisely what happened here. Judge Edward did not get the law right. He accepted the people's there must be a number, there must be a speed theory, and that's legal error. The people continue to cite to the court outdated law, and that is legal error. The controlling standard for the objective requirement has never been met, and that's legal error. Once the right law is applied, the outcome is no longer discretionary for this court. It's not even close. It's not debatable. It's mandatory. If Reyes governs, and Reyes does, I think we're all in agreement, including Mr. Bartos, that Reyes now governs. If the current Cal Crim 520, which I placed on the court's bench, governs, I think, again, we're all in agreement that it does govern, then the murder counts must be dismissed. The case comes down to this, and I'll close my closing comments are these. There's one unavoidable question. Did the prosecution present evidence that Fraser Bohm committed an act involving a high probability of death at the time, that he knew it, and that he intentionally disregarded it? The answer is no. Not a little bit, not barely, not depending on how you look at it. The answer is just no. No intoxication, no racing, no text, no statements of indifference, no prior warnings, no subjective awareness, no prior serious consequences by the government, no bad driving in his history, ever. And no objective showing of a high probability of death to a near certainty. Just speed. And speed is not malice. Section 995 is that safety valve, the safety valve that every member of the community relies on. It prevents exactly this kind of overreach. And the law demands that the murder counts be dismissed so that this case can proceed on the proper charges, the charges the evidence actually supports. Manslaughter, not murder. We ask the court to dismiss counts 1 through 4.
Thank you.
Still with us, Randolph Rice and Richard Grundy. All right, gentlemen, just get your thoughts on this. He's talking about that paint transfer in particular, and how important is that to this case to say that this was a road rage incident? He was reacting. The defendant here was reacting. Randolph, I'll start with you.
Very important, because that's going to be one of their biggest arguments, and that paint transfer is going to verify that there was another vehicle, thus supporting their defense.
Yeah, and Rick, do you think that this defendant will have to take the stand if he is claiming road rage?
Well, I guess if the paint matches or doesn't match some of the other cars that he hit, they could enter it in that way. I suppose he's already given, well, clearly he has given some statements on scene, which include I presume, the road rage. So not definitively, it's another one you're going to have to make a judge whether it helps yourself. But I differ a little from Randall. I think it's a minimalistic help, even if you can show some evidence of it. It was not the appropriate way to react to go 104 miles an hour into Dead Man's Curve.
Yeah, we'll have to see what happens. I think from a defense counsel's standpoint, it's just another thing that you have in your pocket to argue. This young man, he was reacting to Mr. Ortiz's, he was exhibiting road rage, clipped his car. And so I think from a juror's standpoint, they might be like,
Fear
okay.
of his life.
Yeah, exactly. Thanks,
All right,
gentlemen.
thank you for being with us. Thank you, gentlemen, our guests. Don't go anywhere. More from the state in this hearing out of California when we come back.
Asha was wise and gentle. Neve was just joyful and such a light and so kind. Peyton was so driven and just selfless and just the best. And Deslyn was always the life of the party. She was like the confidence. She was your confidence when you didn't have it. They had so many aspirations, so many goals. They were gonna go so many places, and it's truly heartbreaking that their lives were taken too soon.
4 lives tragically taken back in 2023. Hello and welcome to Court TV Live. I'm Julia Janae. Thank you for being with us. This morning, that was Bridget Thompson, the best friend of those 4 Pepperdine University sorority sisters who were killed during a car crash back October 17th of 2023. And the driver, Michael Bohm, he was arrested that day and eventually charged with multiple counts of manslaughter and murder. Prosecutors say he lost control of his BMW while he was going up to 104 miles per hour on the Pacific Coast Highway in Malibu. His defense team, though, says that the actual speed was closer to 70 miles per hour. And you'll recognize the man who is now representing Bohm. He is a high-profile attorney. We know here on Court TV, Alan Jackson, who represented Karen Reed, still represents her in the civil case involving vehicular homicide or allegations of it. She, of course, was acquitted of those criminal charges. And we've just been listening to Jackson arguing to have the murder charge against Bohm dismissed. He's also facing manslaughter charges, but Jackson says that murder requires malice and that simply Bohm doesn't show any evidence of having malice in that moment. Let's get you back inside the courtroom now. The prosecution gets to respond to that request to dismiss those charges.
The defense rightly points out the change in California 520, including the language of high probability that that was the result. But they just ask the question if the people presented that at preliminary hearing. Well, it appears that the judge who held the defendant to answer believed so, when in his holding he said, quote, implied malice requires that the defendant act with a wanton disregard of a high probability of death. That's from the preliminary hearing transcript, volume 3, page 47, lines 14 through 15. The committing magistrate clearly understood the law and applied the law to the facts that he heard. And we're here for a 995 motion. And the question then is, were there sufficient acts for him to draw that conclusion? Understanding he was applying the very law the counsel's been saying he did. I did want to note one thing in terms of the high probability. One of the cases cited by the defense was People v. Pierce at 114 Cal App 5th 508. And in Pierce, they confirm that there has not been a fundamental change to the law. They say, quote, finally, we note that the defense contends the High Court in Reyes, quote, changed its position on the objective component of implied malice and redefined dangerous to human life. As requiring a high probability that the defendant's act would result in death. Contrary to the defendant's argument, the requirement that an act carry, quote, a high probability of death is not new, and Reyes itself noted the equivalence of the Thomas and Phillips formulations, those which came before, restating that the language that already existed stood for the same thing. This is a refinement of the language. And in fact, in the Pierce case...
Why did 520 have to be changed?
No, because it's stating that this already exists, that this is not new. This is the formulation. The change of 520 was a refinement in the language. The standard has always been that the failure to act, even from the previous language, the natural and probable consequences of the act were dangerous to human life.
That's not the same as that's not as stringent as the requirement is.
It is different language, but the point was that that was the language that was provided to, in this case, a jury, and the court upheld the conviction, stating that the language was sufficient based on what was provided to the jury at the time. So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed in isolation is not the determination. Watson and all of its progeny, again and again, they don't provide any definition of what implied malice is. They talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant was driving down an open road with no other vehicles, with no other cars, pedestrians, just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that that stretch of PCH, which the defendant said that he was familiar with, doesn't have sidewalks. This was all information known to the defendant at the time that he decided to engage in the behavior that he did. The speed that we're talking about has to be looked at in terms of where he was and what he was doing. It isn't just that he reached the speeds that he did. He also had to navigate around other vehicles that were going slower. And that evidence was presented at the preliminary hearing. And that he went around because, even according to him, the vehicle in front of him was in his lane, so he drove around. And that's when he was reaching those high speeds. Now, he claimed that that vehicle then started to merge into his lane. So first, let me talk about that in terms of my moving paper saying that about the cause of the accident. The defendant's conduct was the proximate cause of the accident, or the collision, I should say. There is not evidence presented at preliminary hearing or anywhere else other than the defendant's statement that there was any contact between the defendant's vehicle and another. And the physical evidence shows that that did not occur. I don't understand where...
the mirror was damaged.
The mirror was...
It was out of place.
It was out of place. The mirror was out of place in a position that one would not expect to have happened if it occurred while the defendant was passing another vehicle. One would anticipate the mirror would be knocked back as it struck, as it's moving forward, and it would be knocked backwards. The defendant's mirror was knocked forward, and that was after he had exited his vehicle. I could not say exactly how that occurred, but it does not appear that it would have come from striking that other vehicle, and certainly being the fact that the other vehicle suffered no damage on its mirror. The important point then is that this other vehicle is part of the issues that the defendant faces when he gets his vehicle up to the speeds that he did, because people change lanes. And if the defendant is attempting to pass on the right at speeds of 104 miles an hour, and the vehicle starts to turn, he does not have sufficient time in order to control his vehicle.
Does speed equal malice? When we think about malice, we're thinking about intent. The old school definition is wickedness of heart. Did he have that? And is that what qualifies this for a murder case? We're going to hear more from the prosecution after we come back from this break. Again, this is the pre-trial hearing for Fraser Bohm.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help right now, I'm dying.
Don't you have the blood of both these men on your hands?
I feel guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Welcome back to Court TV Live. We are in California this morning, bringing you the pre-trial hearing for Fraser Michael Bohm. He faces there counts of murder and vehicular manslaughter for the 4 deaths of sorority sisters at Pepperdine University back in 2023. And his defense team, they have asked a judge to dismiss those top charges, the murder charges, arguing that there was not enough evidence to show that he had malice aforethought, that he intentionally caused these deaths. Now, the defense attorney is a familiar face to us, Alan Jackson from the Karen Reed case. Let's pick it up where we left off. The prosecution is responding to the defense's argument about the motion to dismiss that murder charge.
He continued to accelerate for another 4 seconds after the vehicle lost traction with the road. As the court said, this isn't just he's going faster and doesn't notice, as Mr. Jackson said. He is being warned by his own vehicle that he does not have control, and yet he exceeds even that speed, which is already far above the limit, and continues on to what the data reported as 104 miles an hour. How could he not have known? In regards to the defense saying that we are relying simply on a slogan to prove that the defendant had subjective knowledge of the dangers of his speeding. It was the defendant himself in the statement who turned the slogan into something personal to him. That he had 2 of his best friends die as a result of speed. The defendant had the knowledge. He admitted that he had the knowledge. The issue is, as Mr. Jackson pointed out, does that mean that forever he could be charged with murder if he exceeds the speed limit by a single mile an hour? And the answer is no. Probably not even 5 miles an hour. Probably not 10. It has to be that he exceeds the speed and does acts that demonstrate implied malice. And here, that's exactly what we have. He knew that the speed, and he said that he believed it was 130 miles an hour, caused the death of his 2 best friends. Again, I'm not saying that the number is 130, but he clearly has an understanding that these excessive speeds can result in death. And it's not certainty, it is more than remote, and I want to get the language right. In one of the citations, and this is from Reyes, citing People v. Cravens, the quote from a concurrence of Justice Liu, although an act that will certainly lead to death is not required, the probability of death from the act must be more than remote or merely possible. And that is absolutely what we have here based on the totality of the circumstances and the totality of the acts that the defendant engaged in, understanding that he had been driving in a manner prior to the excessive speed that was described as going from all the way to the shoulder, all the way to the other side, that he was engaging in behaviors that already drew the other driver's attention to him. And then, at that point, he decided to speed at such excessive speeds. And when I say excessive, we're talking about the actual speed limit was 43% of the speed that he reached. He was exceeding the speed limit by 231%. And as the court noted there, this isn't just about the speed. It's about his knowledge and about where he is engaging in this excessive speed. And he said he knows PCH like the back of his hand. And he knows it like the back of his hand. He knows that people are putting out their trash cans. He knows that people are parallel parking. He knows that people cross on the crosswalk that is demonstrated in the exhibits that the defendant passed as part of his path towards where the collision took place. He knows this, and yet, with that knowledge, with the knowledge that he is already losing control of his vehicle due to the speed, he continues to press down that accelerator for another 4 seconds. And that totality is the basis that the magistrate used to hold the defendant to answer. It is not that there has been no evidence, but that there has been an abundance of evidence, more so than is needed. But the point is, at this hearing, it's whether that evidence was presented sufficient for the magistrate to hold the defendant to answer, and it was.
Very briefly, first of all, first thing I want to mention is that the math is wrong. Didn't exceed the speed limit by 230%. The math is wrong. The speed limit was 45 or 50. 230% would be 145 miles an hour. That's absurd. 100% is double. 100% on top of that is the 45 again. So let's get the math right. And was he speeding? Sure. But I don't want to get ridiculous about this. 230 times? I want to know, what the hell was he in a jet? You got the math wrong. Let's talk about the facts. Provable facts. Mr. Bartos says he was speeding. Okay? That's in a bucket. He's been saying that from day one. He's searching, and the prosecution has been searching and grasping at straws for anything other than that. There are homes at the side of PCH. That's dangerous. There are driveways leading out to PCH. That's also dangerous. There's cars parked along PCH. Boy, that's dangerous. There are trash cans. People have to put their trash cans out. That's dangerous. There's no sidewalks, and yet there's still pedestrians crossing the street. That's also dangerous. He went around some slower traffic, so says Mr. Bartos. Is that dangerous? Maybe, maybe not. And going at a higher rate of speed gives you less time to react. It's also dangerous. Where in that list did Mr. Bartos establish a high probability of death? That's the standard. The prosecution has gotten into this spin cycle non-stop since the preliminary hearing. Boy, this was dangerous, this seemed dangerous, this is dangerous, this is dangerous. That's not the law. As the court rightly turned...
Hitting the pause button on these passionate arguments from Alan Jackson in response to the prosecution's response. Let's get some analysis from our guests. We have with us this morning former law enforcement officer Claudia King and trial attorney Alexis Rosenberg. So great to see you both this Veterans Day morning. Let's talk about Fraser Bohm Alan Jackson's argument, the prosecution's case here. And Claudia, I want to start with you because we've got a case where there are two sets of charges. We have vehicular manslaughter and we have murder. And Alan Jackson here is arguing that murder is too tough a charge. I want to know, with your law enforcement background, how often did you see cases that didn't involve driving under the influence or DUI, but speed and resulted in a homicide, but that murder charges were attached versus manslaughter?
I would say never, to be honest with you. And I think this is a really interesting and potentially dangerous precedent that they're going for here in California to charge second-degree murder here. I completely agree with the vehicular manslaughter, but I'm finding myself more on the side of Alan Jackson right now with his arguments against this second-degree murder charge.
Oh, Claudia King, that's big that you are siding with Alan Jackson on this one, because I know that was not the case in the other big trial that he was featured on here on Court TV. But Alexis, let me talk to you about the same thing, because we're talking, if it's what the prosecution says in terms of speed, 100 miles per hour on a stretch where it's typically a speed limit of 40 miles per hour, residential driveways nearby, people walking, these four girls just walking to get to an event that night. Tell me what you think about the prosecution saying, no, this is implied malice. You go that fast, it basically is that you have complete disregard for life.
I'm agreeing with Alan Jackson and Claudia. I think this is an overcharge. I think to say speed equals malice is a stretch. The bottom line was he was speeding, as well as many people, whether they want to admit it or not, have driven over 100 miles an hour at some point in time and never thought at that point that they were possibly going to kill somebody or intended to kill someone either.
And a follow-up on that, Alexis, though, when someone is driving under the influence, their big argument is that they didn't intend to hurt anyone. They were reckless or negligent, but that they didn't intend it. But it's still implied that if you're going to drink and get behind the wheel, which you are not supposed to do, then that can be a form of malice.
Julia, that's a good point. In many states, the laws related to driving under the influence they kind of made a little carve out back in the day. For instance, like requiring you to do the searching of taking the breathalyzer or taking blood from you, those sort of things. So I think that to give the analogy, is a different, and it also is not a charge necessarily of murder. We're talking usually that is going to be some sort of manslaughter related to driving under the influence if somebody has died.
All right, we've got to get to our break. We're going to keep talking about this case. Ladies, stand by. More of the pretrial hearing for Fraser Michael Bohm. And later, we're also going to give you an update on a Kansas courtroom. They got emotional hearing from the mom of a 6-year-old girl who was found buried in her adoptive mother's backyard. And this was 4 years after the little girl went missing.
I asked God, why her? Why not me? I stand here today to make sure her voice isn't silenced, that her life and the way it was taken is not forgotten. I ask the court to remember this is about a baby girl who was loved beyond measure. I am pleading for the max sentence, justice for Natalie. May God rest her soul.
Sentencing hearing of Christina Schroer starting next hour. Stay with us. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us. Let's get you back into California's courtroom, where we are listening back to a hearing that happened in the sorority sisters murder case against Fraser Bohm. He's a 24-year-old now, was 22 at the time, accused of speeding down the Pacific Coast Highway, also known as PCH, when he crashed into a group of Pepperdine University students, killing all 4 of them, shocking this campus and community. Bohm's attorney, Alan Jackson, who represented Karen Reed during her murder trial this summer, he's asking the judge in this case to drop the murder charges against his client. There are also manslaughter charges that are included. Let's get back inside the courtroom. We're listening again to Alan Jackson's argument to the judge.
not talking about something that's dangerous. Is excessive speed dangerous? If we go out on Van Nuys Boulevard, whatever the big boulevard is, I think it's Van Nuys Boulevard, outside the courthouse, how many folks are going to be speeding on that road? Just, we can look for 10 minutes. How many folks are going to be speeding on that road? Nearly all. Nearly all. It's California, for God's sake.
I don't like the way you're talking about Van Nuys.
Fair enough. Fair enough. I'm making the point, but I don't mean to upset a community, but I'm making the point that speeding can be dangerous, probably is dangerous, but it doesn't in and of itself reflect a high probability of death.
What circumstances would, in your mind, represent a driving that evinces a high probability of death?
If he was high, but he was speeding.
Whether you're high, you're drunk, or whatever it might be, equally, and you're therefore likely to cause some kind of accident. Who's to say whether this accident with drugs or that accident without drugs is more likely to happen to hit a vehicle or a pedestrian and kill them?
Let's say that there's a circumstance in which...
Isn't there a large degree of bad luck?
Luck is not enough. It has to be, yes. Sometimes accidents always happen to a certain degree because of bad luck. But the question becomes, when is it elevated to murder? That's why manslaughter exists. Judge, that's exactly what you're explaining is why manslaughter exists. Because sometimes people are doing things that are inherently dangerous, they shouldn't be doing it, it costs somebody their life. In every manslaughter case, it's important to reflect that I'm not standing up here asking that the entire case be dismissed. I'm saying let's call it what it is. In every single manslaughter case, every one, someone died. By definition, someone lost their life. If what Mr. Bartos is saying is right, basically, well, the car has a system on it that engaged. It was a traction control system. The car's telling him what he's doing is just about to lose control of the car. Well, first of all, that's not how traction control systems work. There's a beep that goes off or a light that goes off on the dashboard. You never hear it. I've got traction control in one of my cars, and you never know that it's going off or isn't. It's embedded in the EDR system, but it's not tapping the driver on the shoulder and saying, hey, slow down. That's not how it works. The question to answer the court's, the answer to the court's question is, what would show a high probability of death? Street racing at 100 miles an hour on surface streets. High probability of death.
Why is that anymore?
Because
street racing cause death than just driving 100 miles an hour?
Because street racing by definition is competitive, and you're constantly trying to outperform the other car. It's coordinated, and you're intending to go as fast as your car will possibly take you. That's the point of street racing. Street takeovers, where you're doing donuts surrounding pedestrians. Nearly every one of those cases that's prosecuted, if a pedestrian gets clipped by a car drifting in circles, gets clipped and gets killed, nearly every one of those cases is prosecuted as a murder. Why? Because it's not just excessive speed, it's losing control of the car on purpose with a pedestrian standing five.
Not on purpose.
Drifting is losing control of the car going out of sorts. In other words, driving it in a manner in which it was not designed to be driven. It's drifting, by definition. So you have far less control. No car is designed specifically for that. It has to be in the hands of a professional. So these street takeovers, they kill people all the time. And normally those are prosecuted as murder cases. Why? Because it has the added effect. You're not just speeding like on the 405 to get around slower traffic. Driving on a sidewalk. Driving when you're evading police. There's always an additive to just speed. That's what Justice Evans was saying.
What about the environment? And Mr. Barker sort of touched on an example that I was going to raise as well, which is, don't you have to consider the environment and the circumstances? There's a difference in the risk of death in driving 100 on PCH versus, some, far out, desert road where you're on a straightaway, there's no other cars, and nobody's around, and you can just go in at 100 and not have to turn the wheel. There's a difference between that and driving on a on a dangerous guarded road like PCH, isn't it?
They're both dangerous, but neither one of those, by just driving fast alone, neither one of those include a high probability of death. People do it every day, Judge. On PCH, they do it every day, and no one dies. It doesn't include a high probability of death. This is an incredibly high burden. We're not saying that it wasn't dangerous. I'm not suggesting that there wasn't a possibility that someone could get hurt. I'm saying that there was not a high probability of death such that Fraser Bohm should be saddled with murder charges. These are the same charges that Bryan Kohberger is facing. That's the point. Bryan Kohberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood. Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt? They did get hurt, so clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it. I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was true.
Alan Jackson there invoking the name of the Idaho student killers, who of course took a plea deal to avoid the death penalty, saying they shouldn't be in the same boat. But we're talking about 2 different states. Let's bring back in Claudia King and Alexis Rosenberg. Claudia King, what do you think about that use of the killer that is probably one of the most high-profile killers of this year, bringing it into this vehicular homicide case?
I mean, it's definitely an odd comparison. It kind of shocks the conscience a little bit to say that. And we're talking about 2 different degrees of murder, you know, 1st degree versus 2nd degree. But I get where Alan Jackson is going in trying to say, you know, this person who deliberately broke in somewhere and slaughtered 4 individuals is a completely different set of circumstances than what my client has done in driving fast and having a crash.
Alexis, is it an argument that's more for flair than for really moving the judge? Because when we cover cases here on Court TV, it runs the gambit. There's 1st-degree murder all over the place, but for some people, it's one person, it's accidental. It's when they were really upset. Others, they lied in wait, they poisoned someone over time. I mean, there are a lot of things in different states that fall under 1st-degree or 2nd-degree murder. So do you think that's really going to have an impact on the judge, this invoking of the name of such a high-profile killer?
Well, this is why Alan Jackson gets the big bucks, because he comes up with this. This actually is a good analogy. And you are right, there are different degrees, and there could be a different sentencing even if he is convicted of that crime. But the bottom line is that right there breaks down pretty much the whole entire argument that Alan Jackson is trying to make.
All right, there's a lot to listen to here. We are going to, when we come back, hear the judge's ruling on this. Plus, courts across the country are dark today for Veterans Day, commemorating all those men and women who serve. And that's the case in Las Vegas for the love triangle beheading trial that we've been watching this week for former adult film star Devin Michaels. That testimony picks up tomorrow. Coming up, a look back at what Michaels said in her police interview that prosecutors point to as the reason why she killed her former lover. Stay with us.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage today on Court TV. This week.
Get your day started with true crime and trial drama. Each morning, we'll take you inside the country's biggest cases before we take you inside the courtroom.
Opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
We'll take you to California in just a moment, but first in Nevada, the love triangle beheading trial that we're watching out of Las Vegas. The jury gets a break today in observance of Veterans Day after 4 days of testimony in the case against a former adult film star, Devin Michaels. She's accused of killing her ex-boyfriend, Jonathan Willett, and even going so far as to remove his head. She's accused of decapitating him. Now, yesterday, jurors heard Michaels' interview with police where she talked about her marriage to the victim's son from a previous relationship.
So what was your reason for getting married to Devin?
Because legally, as my spouse, he has more rights and access to things than someone just as a random.
So like pick up prescriptions?
He can do anything as my spouse. He actually, I had to go into the hospital in the ambulance, and he was the one that took care of all of that.
Okay. So are you guys like intimate together? No. Does he sleep in your room?
Sometimes, like he'll fall asleep when we watch TV, but he usually sleeps on the couch.
He was gonna have to move out?
Debbie was not happy about it, and the idea was John was not supposed to be moving in, but because of the situation going on with his mom, Andrea, he didn't really have anywhere to go. So that's why he was coming this way. And I was not expecting him to do that this fast.
Investigators in this case, they really wanted to know a lot about the relationship here because it was unusual. You had the victim who was in a relationship with the defendant. They had kids together, but her current husband at the time the victim was killed was someone who was a half-brother of her 2 children with the victim. Testimony resumes tomorrow at 2 p.m. Eastern Time. We'll bring you that when it happens here on Court TV. For now, let's go back to California. We are rolling out this important pretrial conference and hearing that happened yesterday. Alan Jackson is representing Fraser Bohm in the death of 4 Pepperdine University students. This happened back in 2023. Fraser Bohm was charged with murder and manslaughter, but Alan Jackson and the defense team for him says that murder is simply not something that is proven by the facts. Let's go into the courtroom now where the judge is about to make his ruling on this motion.
The appellant, Sir Gonzalez, was fully aware of the condition of the accident scene, which would make racing there very dangerous. They had long resided in the neighborhood within yards of where the fatal crash was placed, and inferentially knew the residential nature of the neighborhood, the traffic conditions, and other factors. Mr. Gonzalez was seen driving recklessly in the area just before the collision. The court in Gonzalez referred to Justice Gilbert's remark in the Moore case, which our counsel also discussed, at 187 Cal 937 at 941. Whether Moore was subjectively aware of the risk is best answered by the question, how could he not be? It takes no leap of logic for the jury to conclude that because anyone would be aware of the risk, Moore was aware of the risk. It doesn't common sense as well. How could he not be? Going back to the Gonzalez opinion, the Court of Appeal stated the trial court pointed out that they were engaged in a speed contest at 80 or 90 miles per hour. How much more knowledge do they need? They've got several thousand pound vehicle that they're running at 70 or 80 miles an hour. What does it take for a person to understand that what they're doing is inherently dangerous to human life? Now here, Mr. Bohm was not involved in a street race with another person, but he certainly was driving at an absurdly high rate of speed to the data center in his own vehicle. He also not drunk any alcohol, although Mr. Gonzalez was not stated to have been under the influence either. He was just consumed some amount of alcohol. Just as Mr. Gonzalez was very familiar with the area in which he was driving, so was Mr. Bohm, by his own admission. Gonzalez was aware of the conditions of that roadway when he was driving like he did so dangerous to human life, and indeed likely to cause death. And so was Mr. Bohm, due to his own familiarity with PCH. It should be noted that it was also a factor for the court in Gonzalez that defendant's post-crash conduct was deplorable, and that played into their evaluation of his subjective awareness and his callous disregard for human life. Mr. Bohm, it must be noted, demonstrated no such callousness after this accident. The Moore case, which I quoted some of a minute ago, also was instructive, I believe. In that case, the defendant drove through city streets at excessive speed. He passed one victim going 80 to 90 miles per hour in a 35 zone, ran a red light, collided with another car, which in turn hit a third car, causing the death of one victim and serious injury to another. The defendant did not get out of his car and check on the victims, but continued to drive. When he was arrested, he claimed he didn't intend to kill anyone and did not experience any mechanical failure, but he was simply going too fast. And he admitted that he left the accident scene in a very callous manner. The defendant there conceded, in the talking about the Moore case, that the evidence was sufficient to support a finding of gross vehicular negligence, but claimed it was insufficient to show that he had subjective awareness of the risk for manslaughter. Justice Gilbert rejected this claim. He stated, Moore drove 70 miles per hour in a 35, crossed into the opposing traffic lane, caused oncoming drivers to avoid him, ran a red light and struck a car in the intersection without even attempting to apply his brakes. His actions went well beyond gross negligence. He acted with wanton disregard of the near certainty that someone would be killed, and that's at Moore at page 941. And I think about this, how is that so different from the evidence presented at the preliminary hearing in this case? It's not exactly the same. It doesn't have to be exactly the same. Mr. Bohm was driving at the very least 70, maybe it was 80 or 85, and the objective evidence says it was 100 in a 45 mile per hour zone. He was observed to be driving erratically, moving from lane to lane, causing another driver to at least attempt to warn him to slow down before he hurt someone or himself. Several other drivers also noticed his very, very fast driving. One of them, I believe, honking at him. While Mr. Bohm did not run a red light, he did commit very, very serious traffic violations here by speed alone. I don't believe there was any evidence in this case that he applied his brakes either, not in terms of skids or that type of observable evidence of braking. And here, by his own admission, he knew how dangerous this was. His two friends, his best friends, were killed by driving at an excessive speed, extremely excessive speed, and he's very familiar with the PCH. And again, it's only reasonable to assume that due to that familiarity, he knows what a dangerous road it is, in particular the area called the Dead Man's Curve, where this accident occurred. The magistrate, Judge Edwards' findings that the elements of second-degree murder were satisfied for purposes of the preliminary hearing were well within the realm of the reasonable. The standard is not at prelim beyond a reasonable doubt. That's for trial. I'm not saying what the evidence will look like. If the case does go to trial, whether the case will be proven, whether the murder case will be proven beyond a reasonable doubt, or whether it won't, nobody knows the answer to that. But that's not a question for today. The question for today is whether there was sufficient evidence for the magistrate to make the findings that he did, including the inferences that he made, the law that he applied, and I do believe that the magistrate's finding, of course, well supported by the facts has been applied to the law that's operable in this case. So the motion is respectfully denied.
Motion denied from His Honor. Let's bring back in former law enforcement officer Claudia King and trial attorney Alexis Rosenberg. Alexis, what do you think about the judge's reasoning here?
I see his reasoning. I disagree with it. I think this was an overcharge. They needed to stick with manslaughter, and I think it's going to be a hard battle to get a conviction for murder in this case.
Claudia King, what are your thoughts? And also, I heard the judge there talking about this person who tried to warn the defendant that you're going too fast. The defense, we expect, is going to say that person was actually part of this road rage incident. That was the reason that Fraser Bohm was going so fast.
Yeah, I agree that it was an overcharge. I'm not completely surprised with the judge's decision. I think he just wants to let it stand and move forward, see what the jury does. As far as this other individual, I agree that that's going to be part of their defense. The issue that I see with that is most people who are truly afraid would likely call 911 instead of just speeding up to 104. So I see some issues there, but again, we have Alan Jackson on the case, so there's no telling what he is going to pull out of his bag of tricks.
We have seen him in action, and however you feel about his clients, his arguments are always passionate and masterful when we see them here on Court TV. Claudia King and Alexis Rosenberg, thank you so much for your time. I hope you enjoy the rest of your day.